So welcome back. This is part 3 of our series on what does GDPR really mean for B2B companies. So part 1 was an introduction, knowing your role, controller versus processor. Part 2 was a look at the information technology performance standards that really grow out of GDPR. This part 3 is going to be on data security and breach notification, some really important duties coming out of GDPR. And then in the next segment, part 4, we're going to look at some customer contracting issues and how do you get ready for that. So I think everybody knows that with respect to GDPR, there's really a sea change afoot in terms of the scope and breadth of data security breach notification duties. We know in the US, the notion of you have to notify people if unencrypted data has been lost grew out of the great nation of California, which established this requirement back in 2003. That they wanted, especially for social security numbers or credit card numbers or very sensitive data that could be used for identity theft, for people to be notified if there's a breach so they can protect themselves. Well, that concept has now been lifted, and GDPR is the best example, and placed into comprehensive privacy frameworks that apply to any personal data about an individual. So much broader expansion of the application of the notion of breach notification, and when it applies, can have much greater impact across enterprises, across employee data or customer data or other types of information that's held about individuals. So very significant. Also, the rules under GDPR don't just apply to unauthorized access or acquisition to such data, but even unauthorized loss or alteration or other types of things. So much broader, faster triggers, you might say, to when you have a situation that warrants breach notification. From a B2B customer to provider scenario where a provider is acting as data processor, the mechanics of what's supposed to happen are that if a provider identifies that there's been a breach of security with respect to personal data that the provider maintains as a processor on behalf of its customer, who's the controller, provider needs to tell the controller promptly without undue delay about that incident. And then if it is indeed the type of data security breach that needs to be notified to individuals or to authorities, it is up to the customer as controller to make that notification. Some of the rigor also comes around the timing of that requirement. So the customer, who is the controller of the data, has basically 72 hours to notify the authority about the incident. Now, 72 hours for very small, simple incidents, 72 hours is enough time. But usually within 72 hours for a real incident, you don't know much of anything about anything. So it's a very fast trigger, and there's some unclarity right now, shockingly enough, with the rules as written as to how those time periods stack up. In other words, does the 72 hours that the customer is that get collapsed if the provider has taken 42 hours to get to them, or do they have 72 hours from the date of notification? Anyway, so there's some uncertainty about how this is going to flow. But what is certain is that this is going to cause a lot of attention in the customer contracting process. You can expect a lot more scrutiny, a lot more questions, especially with the heavy penalties under GDPR around questions of liability and indemnities for data security breach. I think for providers, you really are going to need to make sure that you've got the house in order as much as possible, not just around the information security controls, but also how you describe those controls, what it is that you're going to do. You're going to have very good contract management. One of the real challenges if you're a provider and you have an incident is, oh my God, I have 500 customers. What exactly did we promise to each of those customers in our contracts? Apart from the regulatory layer, what is it that we promised in the contract layer? So really important to have good tight control over that. And then also be ready to start accepting some responsibility if there is indeed a data security incident. We've seen this, a long history of this in the U.S. that the customers have said, gee, I want unlimited liability and indemnities if you have a data breach, because of course that's commensurate with the damage that you might cause me, not only direct damages but indirect damages, customer churn, et cetera. And the provider response to that being, well, we're not your insurance company, we're just providing this service. You have this risk because of the business you're in. But sort of the middle ground where things have ultimately gotten to is to have the provider be very granular and specific about what types of information security controls it is willing to provide, and then establishing liability or indemnities based on a failure to comply with the promises that have been concretely made. So better defining the issues and putting some more fences around these types of things. So really important stuff. The only last point I would have is it's important to also be mindful of the cultural context in which this arises. In other words, my expectation is Europe being a civil law jurisdiction, very strict on privacy rules. For incidents that have multi-jurisdictional impact, the addition of the European layer is going to make the management of those incidents and the response more tricky to work through. So that would mean time to double down, not just on substantive information security controls, but also process and procedure for responding to incidents, having good tabletop exercises, etc. So really important stuff.